My name is Craig Campbell, and I'm presenting submission number 81, Imagining Municipalities as Data Fiduciaries. This is a theoretical and speculative paper that consists of four main claims. First, I'll talk about the data stewardship mandate for cities, which is an argument that cities should lead and experiment on data governance the same way they experiment and lead in other progressive policy areas, such as regulating guns or preventing homelessness. Then I'll argue that fiduciary law and fiduciary duties square well with the image of the city as a data steward and are a good test for whether a data policy decision is appropriate. Then I'll discuss the proposal I lay out in the paper, which consists of two normative duties. First, a fiduciary duty of care would require cities to conduct adequate public engagement, expert consultation, and internal deliberation before making high-impact data processing decisions. And second, a fiduciary duty of loyalty would require that data processing is done in the exclusive interest of the data subject. A quick note on vocabulary that I use in the paper and in this presentation. I use the terms local government, municipality, and city pretty much interchangeably. And in all cases, I'm referring to the executive branch of local government. So the offices and agencies from the mayor to the fire department to the housing office, the public authorities that do the messy work of government operations. Why the focus on local government in particular when data governance is an all of government problem? Well, cities have more at stake than other levels of government. Local government is made up of what Michael Lipsky calls street-level bureaucracies, which consist of the teachers, social workers, and police officers that are the human faces of government and the part of government people interact with most frequently and visibly. As street-level bureaucracies rely more and more on data and computation, they risk compromising the trust they need to be effective. In order to establish reputations as trustworthy stewards of citizens' data, cities across the country and around the world are experimenting with different legal approaches to privacy, which Ira Rubinstein calls privacy localism. Cities can give minorities and other disenfranchised groups more power electorally than in national politics, which makes privacy localism a promising way to scale progressive data policy nationally. Susan Crawford has written about this, about how this is currently working with facial recognition technology. She writes, "Thank goodness that Somerville, with its public sector ban, applies a different logic than, say, Plano, Texas, which has enthusiastically adopted facial recognition technology with little public oversight. All of these places can do the hard work of figuring out where the use of facial recognition and biometric data is unethical, inappropriate, or immoral. The hope is that someday, when all the good arguments are on the table and the pain of vendor compliance is too great to bear, the federal government will be shamed by the existence of good local test cases into adopting strong basic rules for data use." My focus is on the standards that local governments are subjecting themselves to, and I frame the challenge they need to solve as figuring out the balance between analytic innovation on one hand and privacy protection on the other. So this thinking is not without bias. My thoughts here are colored by the 3 years I spent working in the Mayor's Office of Data Analytics in New York City. Our mandate was to produce analytic intelligence for mayoral initiatives, improve data sharing between city agencies, and manage the city's open data program. In short, we were tasked with accelerating and enhancing the way that the city used and shared data. In the org chart, we sat directly next to the Mayor's Office of Information Privacy, which was led by the city's chief privacy officer. Their mandate was to facilitate compliance with the city's privacy laws, effectively to limit the creation and sharing of sensitive data across government agencies. Well, in practice, we got along great. There was a tension between the mandates, one of which said, do more with data, and one of which said, do less with data. This, of course, reflects a broader tension in the government's use of data, which is that the more complete the information a government has on the people it governs, the more complete its power over them. Between the scenario where the state has no data and no intelligence, and the one where the state has all the data and complete intelligence is a socially optimal balancing point. I argue that existing approaches to data privacy protection in cities is not working as a way to find that balancing point. So bear with me and imagine a confusion matrix for a data privacy law, which measures the accuracy of the law to predict and prevent harmful data processing practices. The status quo allows too many false positives, where harmful data projects slip through as a matter of creative lawyering, and also too many false negatives, where socially beneficial data processing decisions are prevented because there's too much administrative overhead. Why is this the case? Well, first, in the United States, privacy laws are piecemeal. There are privacy laws for children's data, for instance, health data, educational data, but that leaves a lot of holes for other types of information. Second, existing privacy frameworks are triggered by the existence of confidential types of personal data, such as name, date of birth, or race. But a list of addresses can be just as harmful as someone's full medical history if it's used in a harmful way. Privacy laws are also premised on the idea that if you obtain consent of the user, you're good to go. But we know from social research that consent, especially in areas like public services where you don't have much of a choice, is not a great indicator of someone's preferences and is not a good proxy of how appropriate a given data processing decision is. And third, once data is collected, it's usually the prerogative of a government agency to decide how it wants to use that data, which gives them enormous amount of space for to use discretion in making decisions about data. So the discretion is not necessarily a bad thing, and it shouldn't necessarily be hemmed in, but it should be subject to rules. So going back to the confusion matrix, we want rules that provide a more sensitive and specific instrument for filtering the good government data initiatives from the bad. I make the claim that fiduciary duties of loyalty and care would address this problem and provide that more sensitive instrument. So what's a fiduciary? Fiduciaries are a class of relationships that address the agency problem, which arises when an individual known as the principal or beneficiary places their trust in someone else known as the agent or fiduciary. The fiduciary has a legal duty to act in the best interest of the beneficiary, which entrusts the fiduciary to make decisions on their behalf. What constitutes the beneficiary's best interest is specific to the type of fiduciary relationship. So for instance, the doctor has a duty to the patient to maximize their health outcomes. The corporate director has a duty to shareholders to maximize shareholder value. The pertinent question for applying the fiduciary standard to government data processing is this. If you're a data analyst in a government agency and you have a spreadsheet of 5,000 names of people who are receiving a social welfare benefit, do you owe any ethical obligation to the person embodied in that row of information? When you make decisions about how to analyze data, who to share it with, and how to use the intelligence you produce from it, what duties do you have and what rules do you need to follow? The good news is that several smart people have thought through these questions already. On the data side, Jack Balkin introduced the concept of information fiduciaries in 2014, suggesting that companies like Facebook and Google should owe fiduciary duties to their users. This would require them to place the interests of their users before their own and process their data in a way that was loyal. Balkin argues that fiduciary duties appeal because the rules essentially regulate the social effects of data processing rather than the technical form of the data itself. So the duties apply even if the user has consented and even when their data has technically been anonymized, so long as the decisions that are made are still impactful to them. In a critique of information fiduciaries, Lena Kahn and David Posen write that you can't reconcile a business model like Facebook's with the notion of loyalty to users. The conflict of interest between a user and a business that relies on computational behavior advertising is just too great to overcome. But this critique doesn't hold for government, which already has duties to act in the interest of its citizens, who happen to also be the people that it collects data about. So on the government side of fiduciary theory, although the framework of fiduciaries has developed primarily with respect to private parties in the common law, several legal thinkers have recently theorized the applicability of fiduciary duties to public authorities. Evan Fox Deason and Evan Criddle both argue that the state, when it is governing and enforcing laws, owe duties of loyalty and care to the public that supersede their mandate to follow the will of the president or other political executive who happens to be in charge. There are also theories of judges as fiduciaries, politicians as fiduciaries, local government officials as fiduciaries. So according to these theories that assert the legal robustness of information fiduciaries on one hand and fiduciary government on the other hand, our exercise of imagining local government as a data fiduciary is not just an interesting thought exercise, it is a feasible legal framework. So I'll now discuss how the two main fiduciary duties of loyalty and care would be practically applied to municipal data processing. The first is the duty of care. A duty of care is defined as the fiduciary's responsibility to take reasonable care to prevent harm that could have reasonably been foreseen. So on the surface, it's the duty to do no harm, but it's procedural as well. The fiduciary must take a reasonable amount of steps to foresee harms. In other words, the duty of care is a duty to do due diligence. It's a lot of do's. Max Schanzenbach and Nadav Shuk proposed that municipal government should be subject to the Delaware Model Business Corporation Act's duty of care. This standard focuses on the process, not outcome, of a government decision, and would allow residents to sue the city if they felt that it had not been careful enough in decisions to buy or sell municipal assets. The test is more of an instrument of good governance than it is a tool for opportunistic litigation. Taxpayers aren't eligible for damages. Instead, they have the ability to appeal to judicial review to block or reverse decisions which were made without adequate consideration and public consultation. So for example, if a city signed a contract with a company to install an IoT sensor network in an urban neighborhood, it would have to be able to show its work and demonstrate that the decision was careful and methodical and in the long-term best interests of the city. If the taxpayer felt that it had not exhibited adequate care, they could sue, and a judge would review whether the claim was valid. The judge could then block the contract from moving forward until the city did more careful deliberation about its impacts. It's important that the standard doesn't regulate the decision itself. So ultimately, whether or not to move forward with this contract is the prerogative of elected officials for whom taxpayers have recourse at the ballot box. This standard allows government officials to still have flexibility to do the political deal-making that's required to get things done in government, but it does require that they do so with thoughtfulness and public oversight. In the paper, I hold up the US Census Bureau's decision to implement differential privacy methods on 2020 census data products as an example of a data policy decision that demonstrated procedural care. The Bureau conducted outreach to users of data products, appeared before Congress, and consulted with the research community in order to determine what was the right value between formal privacy guarantees and the analytical accuracy of the data that they will publish. Whereas the census is obviously a highly politicized initiative and therefore naturally in the spotlight, many data initiatives in local government take place out of sight. The duty of care, as suggested here, would require the city to shine some light. The second and stickier part of the proposal is a duty of loyalty. Loyalty requires the fiduciary to act in the sole interest of the beneficiary. Loyalty can be both a proscriptive duty, requiring the fiduciary to abstain from certain activities, or a prescriptive duty, requiring that the fiduciary take some positive action to advance the beneficiary's interest. Applied to government data processing, a proscriptive duty of loyalty would limit harmful or privacy invasive data processing and encourage data minimization. A prescriptive duty would place an obligation on government to maximize the benefits individuals receive from their data and encourage socially beneficial analytics where possible. One of the reasons that a duty of loyalty appeals for government data processing in particular is that it is compatible with the government's obligation to intervene in private lives in ways that individuals might not consent to. For example, home visits for children protective services or arrests for people suspected of criminal behavior. Many proposals for data protection are premised on the existence of fundamental data rights, which allow you to consent and withdraw consent to data processing. But an individual's right to privacy as a practical and legal matter vanishes when the government steps into their lives. A duty of loyalty, however, would persist. Fiduciary obligations are relational concerning the normative responsibilities between parties. They do not depend on the existence of a data right to function as a check on harmful data processing. A government's fiduciary loyalty to an individual's data could be privacy enhancing without conflicting with the government's responsibility in some circumstances to take action, including data collection and processing that individuals have not explicitly given their consent to. So if this conception of loyalty seems very paternalistic, it is, but government is in many ways a paternalistic institution, and I would suggest that this standard is still a major improvement on the status quo. Example I'll give is when New York City partnered with Experian in its rollout of universal pre-kindergarten services in 2014. Universal Pre-K guaranteed free pre-kindergarten services to every child in the city. It is a big deal and saves families a lot of money on childcare costs and allow people in generally lower socioeconomic brackets to give their children the same educational advantages that rich kids enjoy as a matter of course. The city wanted to enroll as many students as possible, so it entered a data sharing agreement with Experian, which aggregates consumer data to create profiles of individuals' creditworthiness. Experian did an analysis of its own data to determine the households it believed were likely to contain a 4-year-old that was eligible for the program. They shared this data with the mayor's office, which used it to target households in their enrollment efforts for UPK. In this case, the city decided that it was an acceptable trade-off to use private data for a purpose other than what it was collected for, given the benefits that individuals would receive from enrolling their kids in the service. You can imagine that if a similar partnership between City Hall and Experian was used to identify households that were delinquent on taxes so that they could be identified and fined, there would be a fallout in public trust because this would be using an individual's data in a way that was not in their exclusive best interest. In other words, using an individual's data to target fines at them would be disloyal. In this case, the calculation was made by public servants who relied on their instincts about what was best for residents, but a duty of loyalty would formalize this kind of deliberation as a legal requirement. The proposal is not without its challenges. The loyalty standard in particular is fuzzy, given that local government has to make decisions all the time about who to prioritize. For instance, there's an active case in New York following recent police protests where the legislature repealed Section 50A of the New York State Civil Rights Law, which prevented police disciplinary records from being made public. A judge blocked the order created by the legislators, citing the potential harm that might befall police officers as a result of that information being public. Under a strict definition of data loyalty, a municipality might think that disclosing records on police disciplinary history would be disloyal despite the clear public interest in that data. Data loyalty would also interfere with any effort to gather evidence to prosecute someone because that data would be used against their exclusive interest. So the entire infrastructure of law enforcement wouldn't work under the strictest definition of individual loyalty. Within a data set, within a single record even, there might be individuals with conflicting perspectives for whom loyalty could mean different things. So to whom loyalty is owed, who is favored in various scenarios, whether individuals or cohorts of individuals are owed the loyalty is not super clear cut, and a duty of loyalty would require additional standards and tests to resolve these conflicts. But I don't think that invalidates the proposal on whole. Part of the benefit of fiduciary duties is that it's a common law tradition, and you can appeal to the mountain of case law to help figure out some of these issues. There's also the question of scope. So what data should be included and excluded in a standard like this? You don't want to cast the net too wide and require careful deliberation every time someone decides to leave a sign-up sheet at a community board meeting. But at the same time, you don't want to give a lot of room for carve-outs that legitimately high-risk initiatives could shoehorn themselves into. Also, should the extent that individuals are identifiable in a data set affect the strength of the duties? Or maybe the loyalty duty to act in the best interest of an individual applies only to personal data, but a duty of care to take steps to reasonably foresee harm applies to all data, including purely infrastructural data that contains no information on particular humans. Finally, there's the question of the scope of government and just how far these duties would reach and follow the polity of local government. I've discussed the proposal with respect to executive agencies that manage their own data, but the boundaries where government ends can get pretty blurry. So for instance, would contractors be eligible to these duties? New York City, for instance, has a contract with Link NYC to provide free public Wi-Fi in city streets. The city was able to leverage its bargaining power to require companies to have a protected privacy policy. You can imagine that fiduciary duties of the city would flow to anyone that it contracts with, as it essentially did in practice in the Link NYC example. What about services that the city uses from other providers? Cities use social media sites like Facebook and Twitter to do ad campaigns, including public health campaigns, all of the time. So under duty of care and loyalty, would a city be prevented from buying Facebook ads on the basis of Facebook's privacy policies not being as strict as the city's own? And finally, there's a question of whether the city should have duties to protect resident data that is not at all collected by the city, but implicitly authorized in the deals that city makes with private developers. Susan Crawford argues that cities have a duty to recognize just how valuable their residents' data is and use that power to negotiate better terms with private developers like Sidewalk Labs or Hudson Yards, New York, which, as part of their development proposals, plan to install sensor networks in urban space, even though the developments themselves are totally private. So the proposal is certainly not without its challenges, but putting the legal technicalities aside, I want to close by considering the proposal's value as a cognitive schema. This is the data set on New York City Open Data that lists details on every inmate in the New York City jail system. It's considered public domain, which means that there are zero restrictions on what you're allowed to do with it. It only identifies individuals by their inmate ID, so it doesn't run afoul of any existing privacy laws. Imagine again, you're the local government analyst or operations manager or agency commissioner, and this spreadsheet with 5,000 rows of inmate details is sitting on your desktop, and you're making a decision about how to match it with data from the probation office or the hospital system to create all sorts of interesting models on inmate behavior and outcomes. I would say that the default status quo in public administration would be to make the decision and then call your privacy lawyers to make sure you're not breaking a law. Having a fiduciary duty, by contrast, would place the responsibility back on you, the analyst, operations manager, or commissioner, to think about your relationship as a public servant to the individual, real people who are represented in each row of data. You would acknowledge your data fiduciary duties as part of your professional identity and ask yourself whether you've exhibited enough carefulness proportionate to the effects of the thing you're going to do, and whether you have been whether the thing you're going to do is actually benefiting the individuals rather than resulting in some administrative efficiency or general intelligence gathering. Daniel Solev writes that today's data processing environment is indicative of a thoughtless process of bureaucratic indifference, arbitrary errors, and dehumanization, a world where people feel powerless and vulnerable without any meaningful form of participation in the collection and use of their information. Fiduciary responsibilities offer a well-developed cognitive framework for delegated trust, sound discretion, and good stewardship that would shift the heuristic for government data processing away from the bureaucratic indifference and dehumanization. For government employees, these duties could provoke a cognitive shift in the image of personal data, not as the digital exhaust of the administrative state, but as an important municipal asset carrying normative responsibilities to the people represented therein. Thanks for listening. I look forward to discussing with you in more detail.